Hello friends, and welcome to another WSIB Truth Matters with Joe Machado on this beautiful Wednesday afternoon. I hope you're doing well. So today we're going to talk about, this is the second of the three-part series on preparing for a hearing. And basically there are different ways to prepare. Each person has their own that works well for them. So I'm not saying that the way that I do it is the best way or the only way. But I'm just giving you my own perspective and also on how I prepared for hearings over the last 30 plus years. That's a long time. Geez, every time I think about that, I'm starting to feel real old. When I think back to when I first got involved in this industry, that would have been about the latter part of 88, early parts of 99 or 89. The tribunal hadn't been around for that long. The Workplace Safety and Insurance Appeals Tribunal. In fact, I believe they were launched in 85 or 86. And the reason why I got thinking about that as I was getting ready for this video is I hadn't had any formal training. And I didn't really know the laws very well beyond what I had attempted to learn to deal with my own case. And I always say I was flying by the seat of my pants. Which seems to be pretty much the case to this day. But I just learned everything I could about the process. And at the time, the tribunal had a couple of videos, VHF. Anyway, those things, nobody has them anymore. But anyway, I get my hands on them, and I learned. I talked about how to do a hearing, and I think at the time, the tribunal, a lot of the processes involved were sort of being defined and put in place so that it could become what it is today, obviously. And there was a big need for it back then, and I think that there's a far greater need for it today because the WSIB is just unrelenting on injured workers and how they're just stomping all over injured workers' rights. So anyway, today's video, I'm going to talk about preparing for the hearing. And so I go through a process, and I'm not going to get into a lot of detail because this would be a very lengthy video, and I'm sure you don't want that. But I'm going to give you some of the main topics of what I did, how I went about preparing to get ready for that hearing. So the first thing I did was a case audit and developed an action plan. And some people confuse a case audit with a file review, and it's not. They're two very different things. Case audit is much more in-depth. It involves research of the law, policies, other cases, medical. It's a very detailed job, but can yield results if you take the time to do it. So with the case audit and the action plan, I developed kind of like a checklist. And I would go through the WSIB file, any documentation that we had gathered in our office. This is with my paralegal firm. I'd go through all of that, file notes on the computer, and then I would review any addendums to the record. Those are addendums. So the tribunal sends you a case record. This is the WSIB's file and any documentation they have pertaining to that case. And they obtained that from the the WSIB, and then there are addendums to the record, and that's information that's either provided by the employer or additional information requested from the WSIB. There's usually a packet of laws and policies that the tribunal believes could apply to the case. So we get all of that information, and you go through it with a fine-tooth comb, and what I would do is create this action plan or and a checklist. And I would look at the strengths of the case and the weaknesses, and I would jot them down, make note of it, and then I would look at whether or not, based on all of the information that was available, whether the weaknesses could be overcome. And sometimes it's challenging. I'd also look at the evidence in the case and determine whether or not it was sufficient to address the issue that I was presenting, whether it be for retroactive loss of earnings benefits or future economic loss or full future economic loss, or Section 43.9 supplement, or entitlement to chronic pain disability. So all of these different types of issues that could be addressed. And so I would look at whether or not there was sufficient information to support the argument. And if it wasn't, then I would make a list of what I thought could strengthen the case. Coffee is especially good today. Then I would look at law and policy. I'd look at the packets that the Tribunal Counsel Office would obtain from the WSIB, the laws and policies. I'd go through that, and they would request laws and policies that sometimes didn't necessarily apply, but they generally requested more than being very specific in the event that an argument was brought up that they needed to address and determine whether or not a different policy could apply. So I would go through that, and you kind of now put yourself in the position of a vice chair or a panel member. And so vice chairs and panel members, these are individuals that are hearing the appeal. They ask questions. Of course, they've also prepared for the hearing, hopefully. And you try to put yourself in their position, understanding the law, having a good knowledge of the case, and looking at what, if you were in their position, what you'd be looking for from the worker. So I often did that because I'd rather, when preparing a client for a hearing, I'd rather ask the question and anticipate that question was coming because the client is more comfortable when you ask a question than one of the panel members or the tribunal vice chairs. And it's not to say that they're intimidating or anything, but it could be an intimidating environment. And for the average person who isn't used to being in that environment, it can be pretty intimidating. So you want to put the person at ease, and oftentimes the tribunal did that. But anyway, back to the issue. I would put myself in the position of trying to think what they would be asking, what would they be looking for, and then write that down on my checklist as well. Once I got through that, then the next step would be to, particularly in medical type cases, I would look for tribunal discussion papers. And those discussion papers deal with a wide range of medical issues. And they can be incredibly helpful if the issue that you're trying to gain entitlement for is covered under one of the tribunal discussion papers. And that can obviously be very helpful in how you're presenting your case and how you prepare and what information. I'm going to get to that in a moment, but I'm talking about additional information that you may need. Then after doing that, I would do a decision search. So I would go on Canly, and this is an organization that tribunals and courts all across Canada are able to post their decisions. And for anyone who's looking to do research or case preparation with a particular tribunal, they can go there, review decisions, and see if there are any decisions that could be helpful. And so what I would look for when looking at tribunal decisions, I would look for decisions that were made where the circumstances and the issue that I was addressing were very, very closely aligned. And sometimes that's not easy because, keep in mind, we're dealing with 3 major legislations over the past 30 years. And the structure of benefits has changed for each one of them. You've heard me say this, for those of you who watch the channel. You've heard me say this on a number of occasions. So narrowing the issue and getting cases that are similar to the ones that you're addressing, if you're not familiar with those 3 legislations, you're going to have some trouble, because then you'll be reviewing thousands of decisions and not trying to hit a piñata with blindfolders. Actually, doing that is probably easier because your search query can really narrow the number if you're very if you understand those 3 major legislations, the structure of benefits, what benefits were paid, how they were calculated, and things of that nature. So, but I would spend a fair amount of time going through that, which leads me to the next one, and that's tribunal jurisprudence. So, whenever you're addressing an issue at the tribunal, and there's tribunal jurisprudence that on that particular issue, that can be incredibly helpful. Tribunal jurisprudence is a consensus of decisions by decision makers on similar issues where they've looked at how each one of them is ruled and use that as a consensus for making decisions. And so I find that incredibly useful. The WSIB doesn't like it. They keep saying, well, we're not bound by precedent, blah, 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 blah. And you know what? Like, put your fucking ego outside the door, and anytime you can learn from somebody else that makes your job easier, that you learn something that can help you in another case, well, wouldn't you want to do that? There is something to be said for consistency. So by making a statement you're not bound by precedent, it flies in the face of reason, because you want to be consistent. And essentially, tribunal jurisprudence really provides that sort of consistency. And AROs know that. They know that if they're ruling on a case and they're deciding against the worker, and there's tribunal jurisprudence that looking at similar cases that were made in favor of the worker, they know it's going to be overturned at the tribunal. But why they play these nonsense fucking games is just fucking maddening. It's sickening. Because you can have somebody who can essentially make a decision, resolve the issue, and avoid a lot of chaos and a lot of stress for the worker. Just pisses me off. And they still do this to this day. The fucking arrogance that they have. Anyway, as you can see, I'm getting a little bit off track here, but tribunal jurisprudence can be incredibly helpful. Ultimately, the biggest decision that you need to make, because this is then going to be communicated to your client, is there enough information, particularly when you're dealing with a medical situation, to support the case? Because if there isn't, and you go into a hearing and you know that you should have obtained additional information, if possible. If it doesn't exist, then you can't do anything about it. But it can be costly, but it makes sense in certain instances to do that, and that's to request an independent medical report, or an independent medical assessment, or an expert assessment. There's different names for them. But essentially what you're doing is, if there's any sort of doubt or uncertainty, I guess those are one and the same, where the condition is the diagnosis is made, the condition is revealed, but there's still some question as to its significance, then, and particularly when the worker is claiming inability to work because of a medical situation, so the stakes are much higher because obviously the payout is higher. It shouldn't be about that, but it is. Then you want to write a very specifically worded letter to an expert, asking some very specific questions based on the information that you have. And of course, you want to furnish that information to the assessor to get a report, to get an opinion. And it can be costly. They can cost anywhere from $500 to a couple of thousand. And I always try to avoid that at all costs, and I would try to get any or as much information I could for the client through the doctor or one of their specialists to try and minimize the cost of getting those reports. But sometimes you really need that because it can make a big difference, especially when the tribunal is, when you're asking the tribunal to consider the benefit of doubt clause. And so the benefit of doubt clause basically states that if the information for or against the case is approximately equal in weight, then the decision must be made in favor of the claimant. That's the worker. So if that report can tip the scale, then it's worth it. I'm not saying that in all instances it's required, but this is just some of the things that I did as I went through the preparation, because you want to get there and you want to put your best foot forward. Your client's been waiting for months, maybe years, and your organization has funded the whole process. So you want to make sure that at the end of the day, there's going to be success. And so pretty much that's how I really handled preparation for a case. And then the last part was a list of itemized actions and timelines that needed to be done so that when a hearing date was provided, you're ready and you're not scrambling to write a letter to a doctor and get reports, and then you're now beyond the date to provide new information. The tribunal may or may not accept it. So being prepared, having that itemized action list and timelines in place is the last thing to making sure that you're good to go for this hearing. All right, friends. So that pretty much concludes today's video. I hope that it was informative. I hope that it's helpful for some of you who are either in the process of going through an appeal with the Workplace Safety and Insurance Appeals Tribunal, or you're contemplating an appeal with the Workplace Safety and Insurance Appeals Tribunal, keeping in mind that there's time limits for everything, so you need to move things along. So I hope that this is informative. If you have any questions, by all means, send me an email. It's in the link of the description of the video. And we do have a product that we just recently launched with WSIBsettlements.com. That's my company. And it's a Workplace Safety and Insurance Appeals Tribunal audit and a hearing-ready review. So it consists of pretty much the audit that I would do when I was handling a case. And during the course of that, I would determine with this audit whether or not the case is ready for a hearing or whether certain actions should be taken to strengthen the position. And so if you already have a representative and you're comfortable with your representative, then that's fine. I'm not asking you to make a switch, but sometimes it's good to have a new set of eyes, have a look at it, have that report in your hands, so that you're in the know. Maybe it can help your representative. Maybe there's certain things that had not been considered. And so this is a tool that we provide. And it's a very intense, very in-depth assessment. But I highly recommend it if you're in that position or if you're considering launching an appeal with the Workplace Safety and Insurance Appeals Tribunal. Okay, friends, so today I'm going to leave you with Mr. Smiley's tip of the day. And right along the lines of what the topic is, here's what Mr. Smiley says. Always go through your checklist a couple of days before the hearing to make sure everything's in order. And some may think, well, geez, a couple of days, you're cutting it short. Well, if you've done your job properly, if you did that audit in the beginning and you have your checklist and you went through each one of those points that I covered, that checklist is just in the event that there's something you were waiting for from your client or from the board or the tribunal, you didn't get it. It gives you at least the next day to try and get that so that you're good to go for the hearing. And it's always good to brush up on the prep so that you're ready to go. I always got up probably about 2 hours earlier than I normally do, and I always tried to book my hearings for first thing in the morning because I hated driving to Toronto at any time. And in those 2 hours, I would go through every aspect of my review. But I have a bit of a photographic memory, so everything that went in there was retained, and I was fresh, good to go, ready for the battle. But that's just me. That's how the way I operated. You don't need to do that. If you go through that 2 days before the hearing, you should be fine. Okay, friends. So I hope you enjoyed this episode. Next Wednesday, the third and final part of the series, and I'm going to go over the actual hearing and what I did and how I went about it, and how I obviously the panel or vice chair, how they handled things, just to give you an idea of what to expect when you go into a hearing. Okay, friends. So, as always, I enjoyed delivering another video with some knowledge that I think can help you. If you're new to the channel, I invite you to become a subscriber. It's free. There's a lot of things you can learn here. I've been doing this for over 30 years. And without bragging, I consider myself quite knowledgeable in all three major legislations before 1990 to present, and over 10,000 clients and hundreds of millions of dollars in settlements for our clients. So, and you get all of that for free. If you need help with your claim, hands-on, then visit us at WSIBsettlements.com. Take a look at what we have, and hopefully you'll find something there that will make you comfortable and that we can handle your case for you. All right, friends, and as always, until the next time, Take care.